Thanks for your patience, everybody.
All right, it looks like we have YouTube live. All right, terrific. So we are now on the record. Good afternoon and welcome and Happy New Year to all. This is a remote meeting of the Energy Facilities Siting Board. My name is Beth Card and I am the Secretary of the Executive Office of Energy and Environmental Affairs for the Commonwealth of Massachusetts and the Chair of the Energy Facilities Siting Board. With me today are the other members of the Siting Board, whom I will introduce in just a moment. But first, some basic instructions on how to best use Zoom for today's meeting. We do have interpreters who will be translating into English and Spanish. To select your desired language, click on the globe icon at the bottom of your screen and select either English or Spanish so that you can hear everything said with interpretation as needed. Please do not check the box that says mute original audio. We recommend this so that you can still hear the voice of the actual speaker faintly in the background, but mostly you will hear the voice of the interpreter. Dial-in participants will hear the speaker's voice without interpretation. However, comments made by dial-in participants will be interpreted. I will ask the interpreter to provide these instructions in Spanish before we continue and provide you a moment to adjust your language settings. Thank you. All right. Now, let me introduce the other members of the Energy Facilities Siting Board that are participating in today's meeting. We have Matthew Nelson, Chair of the Department of Public Utilities, Cecile Frazier, Commissioner of the Department of Public Utilities, Patrick Woodcock, Commissioner of the Department of Energy Resources, Joseph C. Bonfilio, Public Member, Brian Casey, Public Member, and Crystal Johnson, Public Member. Additionally, Andy Green, Director of the Siting Board, will be serving as the meeting host along with other staff of the Siting Board. So thank you and welcome all. Before we begin, I do want to provide some important information about how we will conduct this meeting. The Siting Board meeting today is being held remotely using Zoom. This meeting is being recorded and will be available on the Department of Public Utilities YouTube channel. This meeting is being conducted remotely pursuant to the Massachusetts Open Meeting Law, the Siting Board's regulations, and recent legislation allowing the continuation of remote open meetings via video conferencing until April 1st, 2023. If you are having any difficulties participating, please call or text 857-200-0065 for assistance at any time. Again, that number is 857-200-0065. In conducting the meeting, I also want to note some important procedures that we will be following. All board members must be audible to each other and the audience. If a board member becomes disconnected at any time, we will note that on the record. If there are significant technical difficulties, I will stop the meeting to allow the problem to be resolved. A stenographer is participating remotely who will transcribe everything said to make an official record of the meeting. Board members and other speakers should mute their audio when listening and unmute when speaking. Everyone should please speak slowly and clearly and allow the prior speaker to finish before you begin speaking. These procedures will help ensure an accurate transcript of the meeting and proper translation of the discussion. The Siting Board provided official notice of this board meeting on Thursday, December 29th to the offices of the Massachusetts Secretary of State and the Massachusetts Secretary of Administration and Finance, and also provided this notice to the service list for this docket and to other interested persons. The purpose of today's meeting is for the Siting Board to consider a motion to amend the Certificate of Environmental Impact and Public Interest issued by the Siting Board in a final decision for EFSB 22-01 on November 30th, 2022. Intervenors Conservation Law Foundation and Green Roots jointly filed this motion on Thursday, December 29th, 2022, pursuant to EFSB Regulation 980 CMR 6.054. The motion was distributed after it was received on December 29, 2022, to the board, the service list, and other interested persons, along with additional instructions for today's board meeting. Consistent with the board's regulations at 980 CMR 1.063B, I have determined that it is appropriate to forego written responses to a written motion in lieu of the oral arguments by parties that will be presented to the board at the meeting today. In addition, consistent with the board's regulations at 980 CMR 1.063D, oral argument will be limited to parties in the proceeding. This was communicated last week by email to parties and other interested persons by Presiding Officer Sharkey. Today's meeting is to hear arguments from counsel of record for CLF/Green Roots as to their motion to amend, and responses from counsel for the certificate holder Eversource, other interveners, and from the presiding officer in the certificate proceeding. Following established procedural rules and legal conventions applicable to motion practice, the arguments today will be limited to legal representatives for the parties in this matter. Today is not an evidentiary hearing, nor is it a public comment hearing. It is, however, an open meeting, and under open meeting law, any member of the public may watch and listen, and we have provided that opportunity today, including interpretation services. We will take arguments in the following order: CLF Green Roots on their motion, then other interveners in the proceeding, beginning with the Boston Residents Group. Then we will hear from the certificate holder Eversource. Finally, we will hear from the citing board's presiding officer. As indicated in the instructions issued last week, I ask that arguments be limited to no more than 10 minutes per party. We are now ready to begin the substantive portion of this meeting. There is one item on the agenda this afternoon: consideration of CLF Green Roots motion to amend the certificate issued in EFSB 22-01, in which the citing board granted Eversource 14 state and local permits necessary to construct and operate the proposed substation in East Boston. For the arguments, CLF and Green Roots Incorporated have participated on a joint basis in this proceeding and have been represented by Stacy Rubin and Phelps Turner. I would ask if counsel for CLF and Green Roots wishes to comment on its motion.
Thank you very much, Chair Card. Yes, I would like to proceed if this is the appropriate moment.
It is. Please go ahead.
Thank you. Good afternoon to the board members. I also just want to express my appreciation for what I think is probably the fastest scheduled citing board meeting in the history in Massachusetts and maybe anywhere. So we do appreciate everybody's time. I am Stacy Rubin, Vice President of Environmental Justice at Conservation Law Foundation, and I'm appearing here today along with attorneys Phelps Turner and Angela Mile. We represent both Green Roots and Conservation Law Foundation in this matter. We filed our motion last Thursday seeking an amendment to the certificate precisely because the meeting of the citing board on November 29th demonstrated that there were a number of board members who acknowledged that the process of the 3 different citing board proceedings leading to approval of the certificate could have been improved. I think there seemed to be nearly universal acknowledgement that there was some concern about the fact that, or some tension about the issues around the impacts to the environmental justice population, and the fact that we were kind of late in this 8-year series of conversations, and perhaps things could have been better if done earlier in the proceedings. There were numerous board members who were asking or having a very robust dialogue about the fact that there were these tensions. We do want to thank citing board member Johnson for raising a number of the concerns that our organizations have raised throughout the proceedings during the November 29th meeting. We acknowledge that there were multiple back and forths with various board members, again, acknowledging that there was some tensions here, but the ultimate vote of 7 board members in favor with 1 board member against seemed rushed. We are really here today because we see an opportunity for the siting board to provide direction for the next facility and proceeding that is going to have an impact on an environmental justice population. We are seeking an additional paragraph in the final decision that provides some guidance about what should happen next time around for the siting board when considering a facility that is going to be sited or proposed for siting in an environmental justice population. We are proposing for the additional paragraph to be added to the top of page 173 of the final decision. In particular, we're asking for language that would direct detailed information presented to the siting board in future proceedings addressing and affecting environmental justice populations. The additional detailed information should be including information about demographics, public health impacts, whether a facility is adversely affecting an environmental justice population, and how that compares to impacts for non-environmental justice populations. We'd like there to be language that directs the siting board to require detailed design and site location alternatives. We'd also like the decision to be amended so that it responds to the public comments and explain how those comments were considered and addressed through a tentative decision that ultimately gets approved as a final decision. We'd like to see language that acknowledges that there are environmental justice implications for this proceeding that lingered between all 3 of the decisions between Eversource 2017, Eversource 2021, and now the November 30th, 2022 decision. And lastly, I would just say the siting board has the opportunity to do better going forward. I think there was great discussion led by siting board member Johnson to try to get at some of these issues. And it really seemed that there was an openness from various board members to try to address and wrestle with those issues. We acknowledge that we didn't get the outcome that we wanted in this proceeding, but we are eager to see things improve for the next group that is here at the siting board caring about environmental justice implications. So I'm asking the board today to consider this additional paragraph that really provides guidance for the future siting board. And especially as several of the board members here are on their way out as we plan to welcome a new administration in the coming days, I think it would be enormously helpful if you are willing to vote in favor of amended language that provides direction to incoming board members who are new. It seemed to us that new siting board member Johnson wasn't given a lot of guidance around what was the appropriate way to raise motions or questions or potentially amended language. So we would like for this additional paragraph to be added that provides that type of guidance to the next siting board. And aside from the motion, I do just want to address the fact that we have a couple of questions about what has happened since the final decision has come out. In particular, the company provided updated cost information that is substantially higher than what was filed and the subject of the 6 months plus of conversations that we had during EFSB 22-01. And we would like to know why that information was not calculated and presented during the proceeding. And also, we would like to understand the timing of construction because there was a filing that I think came in today from the company, and we would just like clarity on the record about when the company plans to begin their construction. And with that, I'm happy to answer questions, and I really thank you for your time today.
Thank you very much, Ms. Rubin. Do we have questions for the CLF Green Roots team from the board? Chair Nelson.
Thank you, Ms. Rubin, for your argument today. So I want to start by asking a little bit about two elements here that I see competing and how we can try to resolve that to get to the best possible outcome. So from one regard, I think that your goal, as you stated, was to ensure that future solicitations are done or are take account for some of the changes in law from environmental justice, along with other elements that would be critical to have the siting board, quote unquote, do better when looking at a facility being built in an environmental justice neighborhood. And then the other side is tying that specifically to this filing. And I just want to know if you have a response to whether or not you would want that language to be broader than just for Eversource. Should it also be representative of all future actions for siting board cases, or would you say that it's specific to this case or cases like this one?
Thank you, Chair Nelson. I appreciate you articulating the competing elements. Our goal is certainly to incorporate this language in this filing and to have that be applied as well in future proceedings not specific to Eversource. And our hope is that the assessment of the roadmap law and other relevant laws in future proceedings also sort of build upon, the amended paragraph that we're looking at, and ideally, walk through the legal analysis that we wanted to see in this proceeding. And I also should just acknowledge that we did file an appeal to the Supreme Judicial Court of the final decision, which I think everybody here is aware of.
And how do you see the any overlap between this certificate and that appeal? Do you think they relate to each other at all in terms of if we adopted your language here, would that change your appeal at all, or would it materially affect the outcome of that appeal, in your opinion?
I don't see this amended paragraph materially affecting the appeal. What we're really looking for here is language that is going to be directive for the next proceeding that is not about the Eversource East Boston substation. It's really, again, just picking up on the conversation that I think was flowing well on November 29th, but felt unfinished, that we would really like to see that guidance in this decision.
Okay, and you listed a number of items, and I'm reading here imperfectly because I wrote them down. So addressing issues affecting environmental justice populations, including information about demographics, public health impacts, whether the facility is affecting an environmental justice population, as I think that's relating to the public health impacts, and how it compares to non-environmental justice populations. Is that, did I summarize that somewhat accurately?
You did, thank you.
Okay, and is that, do you feel that's the exhaustive list, or is that just, I'll ask that. Do you feel that it is an exhaustive list, or whether there would be more to add there?
I think there's more to add. In particular, as was noted and acknowledged by various board members, there were a lot of public comments in this particular proceeding, and there were many in the prior two proceedings as well. I think part of the concern that we have is that there wasn't a clear response to all of those public comments. There were a response to parties, but not all of the public comments that were provided. And so our motion also seeks a response to public comments and explaining how those comments were considered and addressed in the decision. Okay,
thank you for that. This is a point of order, I believe, to citing board staff. I think I have questions about, Ms. Rubin brought them up around the budget, but is the company planning on going? Because I'll save it for the company. Mr. Rosenzweig, are you planning on speaking?
I am, Chairman. Yes, I am.
All right, I'll hold my questions for now. Thank you.
Okay, thank you for that. Do other board members have any questions for CLF Green Roots? Ms. Johnson.
Yes, I just have one question. Stacy, can you please clarify when you mentioned that part of the amendment would pertain to making sure that the board members understood the process, because you used me as an example. And I'd love to hear any details on that, because I'm sure it would be fruitful, but I do want to also note that the Energy Facility Siting Board staff has been extremely helpful and offering information. Do you want to talk? And if anything on my side, I did not take advantage of that. So just wanted to kind of separate a little bit on what happened, but wanted to hear from you, if you could, on what your intentions are regarding that aspect of the amendment.
Thank you, Citing Board Member Johnson. So I appreciate your thoughts and kind words about the Citing Board staff. I think, again, as we look to potentially more than half the Citing Board members turning over in the near future, I think we just want to make sure board members understand what they need to come prepared to Citing Board meetings with if they want to see an amendment. I mean, the tentative decision was essentially rubber stamped. There was, no changes. Despite a lot of hours of conversation, there were no changes other than the minor edits that the Citing Board staff had sent just a few days prior to the meeting. So we want to make sure that there is a clear process in place for new Citing Board members so that they understand, if they do have questions about the tentative decision, what they need to do in order to be prepared to seek amended language to that.
Thank you.
Thank you.
Thank you. Excuse me, I'm having a little bit of a cough here. Any other questions from Citing Board members? Okay, well, thank you again, Ms. Rubin and the team at CLF and Green Roots for your argument here today. We're now, I just want to confirm, Ms. Johnson, you have your hand up. I just want to make sure I thought you were all set. Terrific, thank you. All right, so I think next we will turn to the Boston Residents Group, represented by Gail Miller and Francis O'Brien. I think I heard earlier that Ms. Miller was able to join us today. Would you like to proceed?
Yep. Yes, I'm here. I just have a kind of a brief statement. The Boston Residents Group has read the CLF and Green Roots motion and proposed amendment. We do support the amendment as it does address some of the environmental and environmental justice issues raised in the certificate proceeding, and especially in the board meeting held November 29th, 2022. For the Boston Residents Group, the board too hastily moved to conclude the meeting.
I'm sorry, the board what?
Oh,
for the Boston Residents Group, the board.
The board too hastily moved to conclude the meeting and adopt the tentative decision, even as a second day of board consideration had been noticed and planned for. The environmental and environmental justice issues raised by board member Johnson were, for Boston Residents Group, wrongly cut short, especially as the board meeting was the culmination of many months of time and work by all parties in the proceeding, as well as the many years this proposed East Boston substation has been under consideration by the Citing Board. So allowing for a further day of board discussion was very reasonable. The CLF Green Roots motion and proposed amendment does address several of the basic issues Boston residents have raised and will be further addressing them in our appeal. And we respectfully request and recommend that the board. discuss
I-
and approve the amendment. Thank you for, sorry, do you have a question?
Go ahead, please.
No, I'm done. Thank you.
Ms. Miller, I just want to
I-
acknowledge you cut out just a tad there at the end. So, Alan, I just want to make sure you heard what you needed to hear.
I believe I heard everything ultimately.
Okay. Thank you.
Let me know otherwise if you're missing anything. Thank you.
Thank you very much. Do members of the board have questions for Ms. Miller on behalf of Boston Residents Group? Chair Nelson?
Sorry to be super active today, but Ms. Miller, very similar question. From your perspective, this is something you would like to see incorporated into this proceeding, but also into all future proceedings. I just want to make sure that's clear for the record.
Yes, I would concur with CLF and Green Roots.
Okay, thank you. That's it, Chairman. Chair.
Thank you. Are there other questions from the board for Ms. Miller? All right. Seeing and hearing none. Well, now, thank you again, Ms. Miller, and on behalf and the Boston Residents Group for your participation today and your arguments. At this point now, I'd like to turn to see if there are other interveners present who have not spoken and wish to do so. And I would ask that folks please use the raise hand feature to let us know. And I'm directing this question specifically to those that are interveners in the proceeding. Has anyone, are there any interveners present who would like to speak? I'm not seeing any, and I look to the citing board staff to confirm.
That is correct.
Okay.
There is one person who has dialed in, and that person can dial *9 to raise their hand if they are an intervener and would like to comment and have not done so. Not seeing a response to that chair card.
Okay. Thank you. Okay. Hearing and seeing no interveners that wish to speak, we will now turn to Eversource. And I know that Mr. Rosenzweig is here with us today. And do you wish to comment on behalf of Eversource at this time?
I do. Thank you.
Please proceed.
Thank you. Good afternoon, Chair Card and board members. Thank you for the opportunity to speak today. My name is David Rosenzweig, and I am representing Eversource Energy. Also appearing with me are Kathy Cuthan and Cheryl Blaine. On behalf of Eversource, we deeply appreciate the board's prompt action to schedule this meeting to consider the CLF Green Roots motion to amend. For reasons I will explain, the motion should be denied by the board because it is procedurally and substantively without merit. The motion is a clear overreach by CLF and Green Roots. It's an attempt to change the final decision in a manner that is not warranted by the facts, rules, or statutes. Procedurally, the motion is improper. The regulation that the motion relies on, 980 CMR 6.05 provides the opportunity to amend a certificate to correct an unintended error or address current circumstances relating to the certificate itself that was issued by the board. However, the rule is clearly not intended to provide a second bite at the apple to alter findings the board actually made in its final decision. And that is exactly what the motion attempts to do. It attempts to graft onto the final decision significant additional findings, even new standards of review for future applicants that are not specified by statute and that the board chose not to require when it voted on the tentative decision a month ago. The motion makes no attempt whatsoever to amend the terms of the certificate, which are set forth in attachment A to the final decision, including the 14 individual permits requested by the company. The proposed language is devoid of any nexus to the certificate issued by the board. For this reason alone, the motion should be denied. In practical terms, CLF and Greenroot seek reconsideration of the final decision, but notably, the board's regulations have no provision for such a motion. This is consistent with a basic principle that final decisions are just that. They are final. They are not subject to being rewritten after the fact at the request of a party. Instead, the remedy that is available to parties to challenge a final decision is an appeal to the SJC, which CLF and Greenroots are currently pursuing with the court, as is the Boston Residents Group. I caution the board not to fall into the trap of modifying the final decision, given that those findings are fully supported by the record and are in complete harmony with relevant statutory requirements. Not only could that harm the board's defense before the SJC, but it conflicts with the board's prior decisions confirming that the project is in accordance with its statutory mandate. It would also be inconsistent with the SJC's recent decision on the project change filing, affirming the board's determinations. Of equal importance is that this is fundamentally the wrong forum for the board to consider the proposed modifications, which seek to alter the board's future practices and standards concerning outreach, environmental justice, impact analysis, and related issues. Both the board and the DPU have well-developed open dockets, EFSB 21-01 and DPU 2150, to consider the issues raised by the motion. And both CLF and Greenroots are participants in those proceedings where they have advanced similar arguments for future siting reviews. Eversource is also an active participant in those proceedings, as are many other parties who have differing opinions on how and whether to modify those procedures going forward. For the board to preemptively modify the process by which it will review future petitions in this proceeding would be a mistake. The board should be mindful that there is not a complete record in the certificate proceeding to support the findings that CLF and Greenroot seek for future reviews, nor could there be, because this proceeding didn't provide advance notice to all parties in this proceeding that these issues would be addressed in the final decision, and it didn't include all of the key stakeholders who would be affected by the proposed changes. If the board wants to consider these issues for future processes, that's its choice. But as a legal matter, that should occur through the other existing dockets or a separate notice of inquiry. On the substantive side, I need not dwell on that at length because of the reasons I discussed just fully justify denial, but I would add that there are significant problems with the proposed language itself. It misstates the evidentiary record with respect to the company's historical outreach in the community and its consideration of alternative sites, as well as the board's significant efforts to implement EJ procedures that ensure meaningful opportunity for public participation. As I said earlier, the SJC has endorsed the board's implementation of these requirements in its recent affirmance of the project change decision. The proposed language also misapplies EOEEA's current EJ policies and the provisions of the roadmap law. These topics are already comprehensively and properly addressed in the final decision and should not be modified by the board. Any attempt here to wordsmith the proposed language would require a prolonged debate and to no end, since by its terms, the new language would have no effect on the proper scope of this proceeding, that being limited to the certificate requested by the company and issued by the board. At this point, I will stop. The CLF Greenroot's motion is simply without merit, using the wrong procedure to seek an unwarranted relief that cannot and should not be granted. We therefore ask the board to deny the motion. I am available to address any questions you may have. Thank you. And I can wait for Chairman Nelson to ask his questions or transition into a response to whatever may be pending.
Great. Thank you very much, Mr. Rosenzweig. I think before, I know there are some questions that were presented earlier about cost and construction schedule. Before we get to those, I first want to see if any members of the board have questions about the argument that you have presented here before us today. So do board members have any questions? I first see Mr. Casey. I see your hand up, please. Thank you.
Thank you, Chair Card. This question is directly to Mr. Rosenzweig. With the proposed language of on today's session, would you be adverse if that was added or augmented to the outstanding docket EFSB 21-01 as you stated?
We wouldn't. I think Eversource believes these are important issues to consider going forward. We recognize what's going on with changes in policy and changes in regulation and statutes. There are issues that we wish to comment on in further depth that we really didn't address in terms of forward-looking procedures that would apply in the future. There are many other common applicants at the siting board who would probably be in the same position, not just distribution companies such as National Grid, but offshore wind developers that have petitions pending at the siting board, battery storage facilities that are pending at the siting board, and scores of other members of the public or environmental advocacy groups that may not have weighed in as completely as they might if there was a separate proceeding in which those issues came up. So we think it's fundamentally the wrong forum to tack it on to this case at this time. It wasn't a fully developed record, or certainly wasn't noticed to the parties, but those are fair issues. Those are legitimate issues, and we would all be well served to have clearer guidance going forward if that's what the board wishes to initiate regarding these issues, because they are important questions.
Thank you. Thank you, Chair Card.
Thank you. I see Chair Nelson has his hand up.
Mr. Rosenzweig, I asked Ms. Rubin earlier whether she sees this amendment to this docket materially impacting the appeal. And I think she replied that she did not see it materially impacting the appeal. So with that in mind, why do you hold a different view from that standpoint? It seems that this language would not, it's additions to a specific paragraph in the order. Why do you see that as breaking precedent or being a negative impact to the underlying decision rendered by the siting board?
My concern is that it weakens the rationale that the board has stated very clearly at great length within the final decision. And I think that final decision is fully supported on its terms. The intent behind the CLF Green Roots motion is, as I heard it and is stated in their argument today, is that they sensed there were some tensions among board members, that the process was rushed, that there are doubts that lingered with regard to prior decisions that were made by the board. And that undercurrent, I certainly wouldn't want to ripple through as the basis for these amendments as we're defending the board's decision before the SJC. I cannot speak for what the 7 justices of the SJC may believe, but I think on balance, the addition of this language, separate and apart from my concerns about notice and parties that are affected that weren't able to participate, I think lends a question about the fullness of the siting board's review, the completeness of its findings, the sufficiency of the record evidence, all of which are fundamental elements of getting an affirmance from the SJC. The SJC will defer to the agency where the process was fair, the process was complete, the record was full. And if we're going to adopt this language based on an underlying premise that was presented by Ms. Rubin, that there are tensions, there's a sense of rush, there's some lingering doubts, I think that undermines the underlying basic premise on which the SJC would typically review an appeal that's presented to them, such as this one.
So let me ask it a different way, because I do think that the way it was enumerated, the way I heard Ms. Rubin speak about the intentions behind this amendment were related to ensuring that issues related to environmental justice, which I won't restate, are appropriately handled in future proceedings, and not that she's that CLF and Green Roots, who have appealed the the underlying decision. There's no doubt that that's the case, but that they are looking to prevent a situation from happening again. Do you not think that that was what she stated?
That seems to be an accurate statement of her argument. I think if we're going to get to an issue by issue or topic by topic conversation, it's certainly the company's belief, and I believe the final decision speaks to it, that it's processed throughout the reviews of the siting board on the project have been complete, have undergone review under the correct standards, have had comprehensive siting alternatives assessed and evaluated. And the siting board made findings that no clearly superior route or site was overlooked by the company. We believe what we have properly implemented EJ policies on our end, and that the siting board has properly implemented EJ policies on its end, and the SJC has confirmed that. We have a different view as to what's required under the roadmap law. Now, obviously, that's going to get tested at the SJC, but we do believe that we conducted the right analysis in presenting factual information to show that the energy benefits from this project are not outweighed by the environmental burdens that are associated with the project, notwithstanding that it's in an EJ community. So the premise of some of her remarks are that there were flaws or incompleteness with some of these elements in the siting board's review, either in this proceeding and prior proceedings, is something we definitely do not share. And so I would be reluctant to agree, and I would urge the board not to agree to elements that may be at odds with prior orders, or even elements of this final decision itself, where you made affirmative findings about the roadmap law, the EJ policies, the existence of alternative sites, whatever, going down the list of issues that Stacy raised. And there's no problem in my mind if that's an issue or a set of topics that the siting board wants to consider for future proceedings. But to tack it on at this point under the guise of they were not completely, accurately, or fully reviewed by the siting board, there was a rush to judgment, there were tensions, there were lingering doubts, I believe undermines the basic strength of those findings, which are very, very strong in this decision and in prior decisions.
Okay. Ms. Rubin, do you want, I think I would be reticent not to give you an opportunity to reply, since I am the one characterizing your testimony. Maybe if you could reply to the company's position, I think I would find that illuminating.
I would be happy to if that's also okay with Chair Card.
Yes, please go ahead. Thank you.
Thank you. I do agree that Chair Nelson, you are appropriately characterizing what I'm trying to do. I will just note that Mr. Rosenzweig is saying that this amendment is not a second chance for a second bite of the apple, and we're not trying to use this motion to get a different outcome. We have appealed the decision to the Supreme Judicial Court, and that is the forum in which we will raise those concerns. This is merely a motion that provides the board with an opportunity to provide guidance to the future siting board. It should not, this will not affect what happens in East Boston on Condor Street. We're hoping that the Supreme Judicial Court can answer that question, but we don't expect this amendment to do that. The siting board regulations provide a clear path for seeking an amendment, and CLF and Green Roots have properly followed that procedure. We think that all of the suggestions for language that we included in the final decision were based on content that were raised and adjudicated in this proceeding. And we think that particularly there was language during the November 29th board meeting about alternative siting. And there was acknowledgement that perhaps Massport property was considered, but that it wasn't fully investigated to proceedings prior to. We're not trying to challenge that in this motion. The motion is clearly trying to say that alternative decisions locations are considered for the future proceeding in a robust way. So this is really about future proceedings. It's not about the Eversource East Boston substation. I will also note that the EFSB 21-01 proceeding seems very focused on process and not substance. So when we're asking in this motion for looking at the impacts of environmental justice populations compared to non-environmental justice populations, that is not within the scope of EFSB 2101, which is why we don't think that may be the appropriate forum, and that why this proceeding is the appropriate place to seek this amended language.
Okay, I will take a pause because I think I'm taking up a lot of time. I see Mr. Rosenzweig has his hand up, but I'll turn it back over to the chair. I have a couple more questions, and I want to think before I open my mouth about how to best to phrase them.
All right, thank you for that, Chair. Mr. Rosenzweig, I see your hand and invite response.
Thank you, and I will be brief. I appreciate the opportunity to respond. I do believe that it's really would be up to the SJC, and it's hard for any of us to speak definitively as to whether what is being added on here has any implications to the case in chief in terms of the final decision. I think on balance, it would be a negative and not a positive in terms of the strength with which the court would look at the underlying findings, and if they're making the same challenges before the court as they made during this proceeding, whether those were adequately addressed. I also think it's sort of, for the board to decide whether it would be cleaner, whether it's in the existing notice of investigation or a separate notice of investigation, to get the viewpoints of a multitude of other parties that are affected by these issues that have been raised by CLF, and to comment on that in a broader participation be encouraged and be undertaken so that these very important questions get the consideration of the full panoply of entities and parties that would be affected by them. So I encourage the board to look at it that way. And I think in that same manner, the interests of CLF and Green Roots would be met in an acceptable fashion.
Thank you for that. Do other board members have questions consistent with this line of conversation before we circle back to the cost and construction question, and then also, give Chair Nelson an opportunity for further questions if he has them. But do other board members have any questions at this point? Okay, seeing none. I do wonder, Mr. Rosenzweig, if you wouldn't mind, Ms. Rubin asked a question during her argument about cost and construction schedule, and I think we would all welcome an update on those items if you're willing, please.
For sure. I'll start with the second one first and do the first one second. On the start of construction, the company is endeavoring to start construction as soon as possible. It's hard for me to give you a precise date. I will note that the siting board's orders have a condition that we notify abutters twice within the more immediate time frame within which construction may begin. We have notified abutters within a 30-day period already, and we are in the process of notifying abutters that construction may start as soon as 7 or more days after today in terms of commencing construction. The initial stages of construction would be relatively minor to install erosion controls and silt fencing and measures that would ensure that there aren't any offsite impacts from disturbing the earth and so forth as part of construction when those steps take place. So we would expect construction to start soon. Whether it will be as soon as a week or 8 days or 9 days or 10 days, I can't say specifically, but it's in the foreseeable future, in the near term. So that's the answer to that question. On the issue of the cost information, that is pursuant to condition R in the siting board's series of rulings, which requires a pre-construction cost estimate for those parts of construction that are going to be commenced within 60 days of the submittal of that certified cost estimate. The company provided a series of condition R certified cost compliance filings for the 2 transmission lines, the most recent of which was January 2021 for those 2 transmission lines where construction had been underway for a while, and we had made those compliance filings before construction started and then at 6-month intervals thereafter. But at no point did we make a certified cost estimate thereafter for the substation because we didn't have approvals and we were not within a 60-day window for commencing construction on the substation. It was only as of the final decision that we were in a position to be, let's say, within a 2-month period when construction would commence. And we made that certified cost estimate filing promptly after the final decision to correspond to the jurisdictional facility that that cost estimate applied to, the substation itself. The cost increase is unfortunate. It's regrettable. It's, I guess, a reflection of the economic times we're in, where inflation is soaring, labor rates are soaring, material costs, are going up, supply chain issues exist. There's been 8 years of delay in getting construction of this project underway, which contributes to the cost increase as well. These are all uncontrollable realities that exist with respect to this project, at least the substation. It would apply to any other project, and that the siting board might be subject, that the siting board might be reviewing or subject to the siting board's review. It is the economic reality of our time that costs are increasing in at a very quick rate. We wish that were not the case, but the number is the best number we have available at the time. We were required to make the compliance filing, any other filing with respect to the substation in between that last certified compliance filing in January 21 and the one we just made in December. Would have been speculation because the substation was still taking shape subject to permitting reviews and other modifications that may have been imposed on the substation. And it was only at this sort of final step where we had obtained a certificate from the siting board, inclusive of all permits, that the final shape of the siting of the substation was in place. And we promptly made the condition R certified cost estimate filing at that time. So that's sort of the history and background with regard to the issue that was raised by Ms. Rubin.
Thank you for that. Other questions from board members? Chair Nelson.
So this is the final cost estimate. Is that correct?
It's the final pre-construction cost estimate. Under the condition, Chairman Nelson, we're required to provide ongoing updates regarding that estimate as it evolves over time. It will reflect in part actual costs and in part projected costs as different stages of construction continue. So it's an ongoing process that continues until we complete construction, and then we provide an after the fact, not estimate, but final accounting of what those costs were as of the completion of construction. So this is sort of step one for the substation, and will continue for the next at least couple of years, because it's about a 24-month construction schedule for the substation. So there'll be several other.
Okay, so you won't have final costs, obviously, until the project's complete, correct?
That's correct.
Okay, and when do you seek cost recovery for this project?
Some of the costs are subject to FERC review, and some of them are subject to DPU review. So you know as well as I the standards that apply for DPU review. It needs to be used and useful. It needs to be in service. It needs to be part of the test year. And then they would be subject to DPU review as to the prudence or reasonableness of those costs. And there would be an opportunity to assess that if the costs are excessive or wasteful, and if you will. FERC has a slightly different process, which involves a future test year, if you will, but also those are subject to challenge or review at FERC as they are incurred and reported to FERC before they go into rates.
And that those costs would be divvied up by the portion of the project related to the Greater Boston Reliability Transmission project, and then those costs that are more related to distribution related costs. Is that correct?
That's right. And there's actually two buckets, if you will, on the FERC side. We don't need to get into it in any detail necessarily, but there's those costs that might be regionalized in transmission rates, and those costs that might be part of more localized transmission rates. All transmission companies have two different sources of rate recovery for the transmission projects: regionalization, when they're part of an ISO approved solution, and local network service, which is needed to fortify or support upgrades to the transmission system that are not at the regional level, but are more on the local level. So there's an apportionment there that applies as well.
Okay, so, and I mean, you were speaking in that in sort of a hypothetical way, but this seemed to have been an ISO approved reliability project. Is that the intention at this time? Which path you're going to seek recovery through?
The transmission lines are, in fact, regional in nature. The substation itself is more on its localized transmission upgrades, as well as down a level to distribution, which would be through distribution rates.
Okay. And the company is currently in a stay out, right? And so it would have to complete the project and then file for recovery through a rate proceeding, correct?
That's correct. It does not add automatic recovery. We would have to follow the terms of the most recent rate order that was issued by the department and apply for that recovery when allowed to under that rate order for purposes of distribution rate recovery and rate base.
Okay. And subject to a prudency standard. Okay.
Yes.
I think I'll have some questions for siting board staff, but I have no more questions at this time.
Thank you. Do other board members have questions for Eversource? All right. Thank you, Mr. Rosenzweig. I think with that, we will now move to the presentation by the EFSB presiding officer, and I would ask the Siting Board's General Counsel, Joan Foster Evans, to please comment on the motion.
Thank you. Good afternoon. My name is Joan Foster Evans, and I serve as General Counsel of the Siting Board, and I would like to address the board regarding the motion to amend the certificate. On December 29, 2022, Conservation Law Foundation and Green Roots filed a motion pursuant to the Siting Board's regulations at 980 CMR 6.05 paren 4, seeking an amendment to the certificate issued by the Siting Board in its recent final decision in docket 20 EFSB 2201. In the certificate decision, the Siting Board issued 14 state and local permits needed for construction of a substation in East Boston. The motion is filed pursuant to a provision in the Siting Board certificate statutes at General Law, Chapter 164, Section 69K and 69L, that provide for amendment of a certificate already issued by the board. This motion follows the December 19th, 2022 appeal submitted by CLF and Green Roots and the December 20th, 2022 appeal by Boston Residents Group to the Supreme Judicial Court, seeking to vacate the board's final decision and remand the certificate request back to the Siting Board. The Siting Board's regulations provide that the board may either deny the motion or schedule a hearing on the motion. Siting Board staff recommend that the board deny the motion to amend the certificate because it is procedurally deficient. The motion to amend in and of itself does not ask the board to revoke the permits contained in the certificate or even modify them. Instead, it asks the board to amend the final decision to reflect environmental justice concerns of CLF and Green Roots. Further, the motion asks the Siting Board to commit to various environmental justice practices in the future. Indeed, today CLF stated that the amendment does not affect or not intend to affect the current certificate decision itself or the East Boston substation. As I will explain, the staff view the motion as procedurally deficient and the information in it better addressed elsewhere. First, let me start by noting that a final decision for a certificate actually contains two separate components. There's the final decision, and second, the certificate, which is attached to the final decision as a compendium of approvals in lieu of specific state and local permits normally issued by other agencies. This distinction between the final decision and the certificate attached to it is important. The regulatory provision under which CLF and Green Roots filed the motion to amend the certificate at 980 CMR 6.05 paren 4 is specific to the certificate. The regulation says nothing and does not contemplate motions to amend a final decision. Unlike our sister agency, the Department of Public Utilities, which does have a regulatory provision to consider motions for reconsideration of a final order, this concept is absent from the Siting Board's regulations. Our view is that the CLF Green Roots motion to amend the certificate is inconsistent with the letter and spirit of the regulation under which it was filed, which contemplates amendment of the certificate and the permits that it issues. The proper form for reconsideration of a final decision is the appeal that they have already filed with the SJC. Furthermore, even if the board would adopt the motion as filed, it would provide no relief or reprieve from the pending appeal. The proper venue for review of the certificate decision is the SJC, and the decision is already there under review. I'd like to say that the motion to amend also cites a robust discussion on environmental justice considerations by board members at our last board meeting. The motion to amend contends that somehow the concerns expressed there were unresolved during the board meeting and now warrant the proposed amended text in the final decision. It is staff's view that the board conducted the meeting pursuant to and in compliance with its procedural rules, and ultimately voted to approve the tentative decision with amendments for issuance as a final decision. The board completed its review of the certificate. The motion to amend did correctly observe that the Commonwealth's environmental justice laws and policies are of great importance to the Siting Board, a topic discussed frequently at length and sometimes with spirited debate at board meetings. Staff shares CLF and Greenwood's interests, as stated in the motion, in exploring and advancing environmental justice considerations in siting board proceedings in the future. In fact, there are already several ongoing efforts involving diverse stakeholders. Let me name a couple of them. First, the siting board has been actively participating in environmental justice working group of the EEA Secretariat. As part of the EEA Secretariat-wide EJ strategy effort, the siting board has prepared a draft environmental justice strategy that has been distributed for comments from stakeholders through January 27th, 2023. Second, as discussed here in the siting board meeting, the siting board has issued a notice of inquiry in EFSB 2101 to explore ways in which the siting board can better encourage enhanced participation of the public, especially environmental justice populations, in siting board proceedings. This proceeding is ongoing, and the siting board has received numerous comments from a broad array of interest groups and conducted a joint roundtable with the DPU and may convene future public sessions and work groups. While the certificate proceeding involved only Eversource as the applicant, the NOI is applicable to all applicants and facilities reviewed by the siting board. Thirdly, as Greenroots and CLF are aware, the siting board has also been participating in voluntary informal discussions with various federal agencies about its EJ practices and policies. And finally, as the new governor takes office this week, the new board members will be appointed and may wish to weigh in on these important matters. In short, we believe that these efforts involving many stakeholders are the appropriate location to develop generic, forward-looking, industry-wide practices and should not be determined by the specific EJ commitments sought by CLF and Greenroots in their motion to amend this particular certificate decision. Staff believes that the motion should be addressed in another place. One final point raised by the motion to amend deserves mention. The motion notes the protracted nature of having 3 proceedings for this project plus 2 appeals, and that this is not the best way to address energy siting issues and an environmental justice population. We agree. The series of proceedings and appeals for this project have been very time-consuming and resource-intensive for us all. However, this long procedural history in part reflects the fact that comprehensive policies continue to evolve in this area. As we review projects before us, we endeavor to incorporate the changing policies in our proceedings, and we welcome the stakeholder contributions to this effort. We believe the NOI can provide guidance as we move forward in this area. In sum, for the reasons I've just described, the siting board staff recommends that the board deny the motion to amend the certificate as submitted by CLF Greenroots. I'd be happy to answer any questions. Thank you.
Thank you, General Counsel Foster Evans. And so now we'll see if there are questions from siting board members. Ms. Frazier, I see your hand up.
Thank you, Chair Card, and thank you. I was trying to remember your correct title, Joan.
General Counsel Evans.
General Counsel Evans. I wanted to say presiding officer, but I know that's not correct. So thank you for your presentation. I just want to understand the piece about the deficiency of CLF's motion, and that it attaches to the certificate, so there's no appropriate means to amend the final decision as CLF wishes. Is that correct?
The citing board's regulations provide a mechanism to amend a certificate and the permits that it issues. And that's this regulation that we've been citing. For instance, if the permits were issued and there was some condition in them that for some reason an applicant could not meet, the citing board has a mechanism to go ahead and amend that certificate. However, the citing board's regulations do not have a provision to reconsider a final decision. And in essence, this is what this is doing. It is putting additional language in the final decision. There is not mechanism to do that under citing board regulations. The way that the citing board rules are set up is that if someone, a party, disagrees with the citing board's decision, wants to change it in some way, they appeal it up to the SJC, and that is what has been done here.
Thank you for that. I appreciate the clarification. I do have two other questions, Chair Card, if I could at this time.
Yes,
they should
please
be
go ahead.
brief.
Sure. Go ahead.
As to the issue of another forum for addressing the issues raised in the proposed amendment in the motion. There was earlier comment that the public participation docket is process driven, so might not be the appropriate venue. But based on what I heard you say, there is a way to address these issues in that proceeding or some other proceeding. Is that correct?
I think that there are ways to address the ideas in this motion, and there are extensive ideas in the NOI. We think that the NOI is probably the best place to address it. But if we were to address these issues in the NOI, I do believe that the NOI scope would need to expand, and we probably would need to provide some additional process in order to do so. Some additional notice that the scope of what we are looking at has been expanded to include the issues that CLF and Greenwoods raise in their motion to amend.
Okay, thank you for that, Joan. The final question I have is about the appeal to the SJC, and I know you can't read the minds of the justices, but what effect is this likely to have on that appeal? If you could speak to that based on your experience.
I do think that some of the language that's in the motion to amend does undermine the appeal. There's some language in there that talks about acknowledging certain deficiencies in the process. We would not want to include that language because of the pending appeal. I think that the language also could be read to conflict with some of the other findings in the decision. And remember, this is just motion practice today. We're not taking evidence here. If there were evidentiary matters that needed to be addressed, we'd have to do further process here in order to address them. This is just argument. So I would not want conflicting information to be inserted into the final decision, especially where it is up on appeal by two different parties.
Thank you, General Counsel Foster Evans, and thank you, Chair Card. I have no further questions at this time.
Okay, thank you very much for that. I see Chair Nelson with his hand up.
Can I follow on that thread, Ms. Evans? So I just want to recount. Is it a matter of adjusting the suggested language by CLF? Because you were saying the language could conflict with other findings in the decision. Is there a way to make that comport? Or do you think just your foundational issue around the certificate is not the appropriate vehicle for this is overlying? Like, could we deal with the language issue, or do you not think that's possible?
I think that the overarching issue is the fact that this is not an amendment of the certificate. This is something else. And therefore, I think the board should not be amending a certificate when they're agreeing to amend a certificate when they're not amending a certificate. I think that's the overarching issue here.
Okay, but you also said earlier on when you were talking to Miss, I think to Miss Fraser, it might have been in your statement, that the siting board agrees with the ideas presented by CLF, or I might be putting words into your mouth there, at least that you saw merit in some of the ideas presented by the CLF and Green Roots and the proponents here.
So when I said we agree, it was to the statement that three proceedings and 2 appeals is not a good way to, not the best way to address projects in an EJ community. This very conflicting type of approach here. That's what I said we agreed to. I think that there are many issues in the motion to amend that deserve further reflection and input from multiple stakeholders. And I think they are issues that are worth exploring, but in a more broad and inclusive manner.
Okay. So your statement would be, and disagree with me if I don't get this right, that that there should be more process to determine generally better rules to the road for all parties as it relates to the issues that were brought up in the certificate amendment. Is that more accurate?
Yes, I think a broader set of stakeholders should work on these issues, and it may be that the NOI is the best place to do that, where you already have a process and a broad stakeholder representation.
Okay, and Ms. Rubin expressed some doubts that that proceeding, I think it was 2150, or was it 2101?
2101.
2150 is the DPU's version.
No wonder I got confused. That was more focused on process than substance. And you had mentioned that there may require to be some more notification or notice if we did anything with that proceeding. Do you think that that notice would allow more substance to be incorporated in the docket as it related to this issue that was being raised by CLF and Green Roots?
Yes, I think that proceeding could be opened up to a broader focus than it is currently now to address and explore the issues that are raised by CLF's motion to amend.
Okay, thank you.
Thank you, Chair. I see Commissioner Woodcock has his hands up.
Thank you, General Counsel Evans. As I look at the regulations that's cited for this, for the amendment, the language in the regulations are fairly broad. I mean, my reading of it is any party to the certificate proceeding or aggrieved party may make application for amendment of a certificate. If I understand it correctly, you are saying that consistent with how that has been operated, those are more technical amendments, or they are requests for amendments that could, I think you described it as that the petitioner could not meet. Do I have that characterization right?
I use that the petitioner not meet was intended to be an example, not a limitation on, it wouldn't be just that. I was trying to use an example.
Okay. Have we, I'm unfamiliar of this happening since I've been on the board. Are there recent examples of this?
There are not.
Okay. You do think that, could you explain a little bit more? I think it goes to the crux and how Commissioner Fraser was asking, but could you explain again why you think that the the request for amendment from CLF is inconsistent with the regulation?
Because it is our view that reading the regulation in conjunction with the statutes from which the regulation was written, that the intent of this provision is to allow an amendment of the certificate itself. It talks about a certificate that's already issued, and it's an amendment of certificate, not an amendment of the decision. With amendments, quite frankly, they're unrelated to the certificate itself.
Okay. I think I'm hearing, there's a distinction here that it needs to be within the contours of the final decision. Or is that right? That
within the contours of the certificate, yes. It's not to reconsider the certificate, it's to amend the provisions of the certificate itself. It's not to say, oh, we don't want the certificate anymore, or we want something else stated in the decision. It is amendment of the certificate itself.
Okay, thank you. That's very helpful. And then secondly, if I could, Chair, I just wanted to drill down on the NOI. I mean, so procedurally, from your assessment, the foundation of how the Energy Facility Siting Board is within our statute and then the regulations that embody it. Can you walk me through from the NOI where you would see this procedurally leading to process changes at the EFSB?
So the NOI is intended to be generic and forward-looking, right? And I think that a lot of what is in the motion to amend is generic, industry-wide, forward-looking type changes. And the way I see this happening is if we include, let's say we include the motion to amend ideas into the NOI, we need to provide some process because it would expand the NOI. But then we could get discussion and input from multiple stakeholders on how best to implement those ideas. Because right now they're kind of generic ideas, and we need, obviously the devil is in the detail, and that's what takes some time to implement it properly so that the board could meet those standards going forward.
How would that be affected? How would you implement that? Is that within a proposal to change the regulations of the EFSB ultimately?
We do not have a final mechanism right now, Commissioner Woodcock. We could do it through regulation. We could do it through an order of the board. We could do it with a set of guidelines. Sometimes that's easier to implement than regulations because of the narrowness of regulations, how hard they are to change. The board could issue a policy document. There are various ways the board could do this. I believe what the department has recently done is issued a straw proposal on pieces of its notice of inquiry, and that's a possible vehicle also. I like the straw proposal idea personally because it gives people something concrete to react to and to improve. But it could be in any of those methods, and it may be a combination of those methods depending on what is the change that we wish to implement. And it may also be that the changes are phased. You implement some, and then later you implement more. I could see that happening also.
Okay.
Perhaps Ms. Sharkey is actually the presiding officer on the NOI. She might want to add to my comments there on procedurally how the team views the NOI playing out.
Sure. Where we are in the, in the NOI, what we had done initially was it was open in at the direction of the board in the context of trying to improve notice and participation by, among other things, EJ communities as populations which face hurdles in participating in our proceedings. But it also discusses very generally at the beginning of the vote, which opened the NOI, looking at environmental benefits and burdens consistent with the Roadmap Act. One of the things that we've done is in connection with the notice was solicit comments. We had a roundtable, and we've actually proceeded to attempt to implement things that were suggested by commenters through that proceeding, such as, providing specific web pages, providing better opportunities for the public to access information. But that's not necessarily the limitation of what could be addressed. I think part of the value of the NOI is that the stakeholders who are participating in it are people who would have specific concerns regarding the siting board proceedings, how people can participate in them, what measures they would like to see the siting board undertake as part of their reviews, and they're already participating in that proceeding. So it's not like you would have to go out and solicit a new group of people and say, think about this issue. What proposals would you like to see? Can you present people to specifically focus on a particular issue? We can do that without the need for necessarily reopening a specific new docket and taking the time that's necessarily involved in issuing a new notice, distributing it to parties, having initial meetings. This could expedite the process of addressing these issues. And that's would probably be the value of moving it to the NOI.
I don't think I have additional questions. Thank you, Ms. Sharkey and General Counsel Evans. I may have some comments later, but I think those answer my question.
Okay, thank you. Do any other members of the board have questions at this point? Seeing or hearing none, and recognizing that our next step is to move into the deliberations portion of our agenda. I wonder if a 5-minute break or so is in order, and maybe if now is a good time to do that, if a break is warranted.
Might I ask for 10?
Of course.
Thank you.
Okay, so we'll take a 10-minute break. So let's see, my clock says it's 2:33. Let's make it easy and just call it 2:45 when we'll come back. And so we'll look to resume the conversation, and we'll begin our deliberations at 2:45. So thank you to all the participants. See you in 10 or 12 minutes. Thank you. So if staff will just let me know when we have all of our board members and participants back. I think we're still missing a couple.
Okay, I believe we are all present now.
Terrific, thank you. So just before we took our brief break, we had wrapped up a presentation from General Counsel Evans and had some exchange of questions. Folks had indicated that there were no further questions at that time. I'm going to assume that that is still the case unless anyone sort of waves up and down now, and we will proceed to deliberations. Okay, in order to begin deliberations, we will need a main motion before us. So as was mentioned, the purpose of today's meeting is for the board to consider whether to grant or deny the motion to amend the certificate as filed by CLF Green Roots. So the way this will work is we'll start with a motion and a second, and then we will have some discussion. So let me first see, do I have a motion to grant the motion to amend the certificate filed by CLF Green Roots?
I so motion.
Do I have a second?
I second.
Thank you. Okay, so we will leave the main motion on the floor for further discussion. And let me just note that the board members can now deliberate on that motion and can consider whether there is interest in making additional motions or amendments to that main motion. And again, board members should feel free to ask questions, make comments, and suggest specific language as we go through this process together for any additional motions that may amend the main motion that is before us. After deliberations are through, we will return to the main motion inclusive of any amendments that the board has voted to include. So I will look now to fellow board members to see who would like to begin the discussion here today. We've had some good presentations and hearty engagement already with parties, and so I think some ideas were starting to surface. It looks like Chair Nelson would like to begin the discussion here. So Chair, please.
Thank you, Chair Card. So I think that from the discussion we've had today, I think I've heard, at least from the board members that have spoke, some general support for the intentions behind what this motion is aimed at, which is improvements, real improvements at environmental justice in proceedings going forward. I think Ms. Rubin spoke fairly eloquently about the issues at hand and has indicated that the real goal of this amended certificate is to try to put some protections and changes in for environmental justice communities when a facility is being sited in those areas. The main discourse that I have heard is where and how we should do it. I've heard the company oppose putting this into the actual language as proposed. I've heard concerns from siting board staff regarding the way in which that would be done procedurally. And I've heard a couple suggestions that it may be more appropriate as an NOI, but that brings some concerns as well. I'll start by saying I would certainly prefer to enhance our existing environmental justice standards as soon as possible. Throughout the entire proceeding that we've done on East Eagle, I think we've tried to improve our already existing procedures to be more inclusive and be more accessible to the public. I think I see this as an extension of that, and I think the spirit of it is well-intentioned. But I'll pause there and kind of say that's my summary, and I think the issue is kind of how and where we should look at this. But if people want to say that they're not sure that the intention is well placed, we could discuss that as well.
Well, while we wait for others to put their hands up, I want to express my concurrence with how you've summarized the intention. I think being more inclusive and accessible in these types of proceedings is the direction that Massachusetts as a Commonwealth is going. I think we need to go in that direction. And I think from my perspective, like the possibility or the potential of sort of doing more, and to use your word, Chair, enhance the process of these types of proceedings beyond just one project, but to sort of think more holistically and bigger picture in terms of how the board functions and how our proceedings are conducted. So I am agreeing with your statement and just putting a finer point on, I think this is something that, to the extent we have an opportunity to do so beyond just a project that the East Boston project that's before us, but more big picture, I would endorse finding a way to do that. Ms. Johnson, see your hand.
Yes, thank you so much. I appreciate what you had just shared and everything that has been shared. I just want to add just briefly that I value the spirit and the intentions and the clarity that it provides. And I do recognize that the board is the appropriate place for making that decision on an amendment versus some comments saying that it is not. So I just wanted to bring that up. And that is it.
Thank you. Do others have thoughts on this concept? Mr. Bonfiglio, thank you.
Yes, thank you. I think I agree with most of the sentiments that were expressed, that the general intentions that were laid out were very well founded. But I still somewhat confused as to whether or not it was relevant to make. I think the decision or the position that was taken that the issues were valid, but perhaps better addressed elsewhere with a broader set of stakeholders. So if the intention is to move the needle as far as we can or need to with respect to environmental justice, why wouldn't we want to have it in a forum more suitable for that so we could get comprehensive input from all the parties that need to weigh in? Because if this amendment and this motion to make the amendment doesn't have any relevance on the decision for East Eagle that we've already made, then it's kind of confusing me as to why are we making it now as opposed to addressing it in a forum that's more appropriate for it. So, and I keep going back and forth on that in my head. So that's just kind of where I'm sitting at this point.
Thank you. Chair Nelson, do you want to weigh in and offer some clarification on how you think we proceed?
Yeah, I think Ms. Rubin did articulate, I think, pretty well that the intention is to make meaningful change. I think that it is proposed here in the certificate case, and I understand why it's being proposed here in the certificate case. But as long as it was renoticed in the NOI to be more substantive, and the staff took it that way, I think it would have a similar outcome and would allow this to apply not just to, an Eversource specific case, but also apply to any of the other facilities, whether it's any of the utility companies or any of the developers doing offshore wind or solar or storage projects that are going to be sited here in Massachusetts, because there's many different types of energy facilities that could impact environmental justice communities. So I agree that having a broad base is probably preferable.
I would agree with that, Chair Nelson, I think. Oh, Chair Card.
Go for it, Commissioner, you're fine.
I kind of just jumped in. Yeah, I think, we'd want to have robust engagement and discussion and, the broadest possible stakeholder set as been articulated. These are important issues. And I think if we can have that type of proceeding, it would be beneficial to everyone going forward.
Thank you, Commissioner. Mr. Casey, I see your hand.
Thank you, Chair Card, and thank you, fellow board members. Sorry for my simple question, but I just following up on Joe and Chair Nelson. I think we're in violent agreement. I think we all agree that EJ as an issue should have a set of procedures and protocols associated with decision making, but that it's not this specific certificate. Is that are we all in agreement on that? Like it has a place, but it has to have a larger appeal for more stakeholders to shape that kind of debate and shape those rules and procedures, but it's not germane to this proposed amendment. Is that accurate? Is that what we're saying?
I think that's what we're saying.
Okay.
I'm looking at whether heads are nodding. I see Chair Nelson nodding as well. I don't want to speak for him. I see Ms. Johnson has her hand up. Do you want to weigh in on that question?
I just have a question because I value everybody's point. I appreciate, Joe, what you had just shared. And I was not thinking that it was necessarily would prevent continued or the larger stakeholder advancing that type of conversation. So can you clarify that supporting this amendment, why it would block a larger discussion or other stakeholders from advancing EJ discussions or such? I didn't think it was such an either or. Can you clarify that for me, please? Thank you so much.
I'm sorry.
I don't know if
can't
that-
see who is speaking. Go ahead, Joe.
I don't know if board members Johnson's questions, was it directed at me or?
No, just anybody who could answer. I appreciate that you brought up the point though.
Okay.
But you didn't have to necessarily answer it. But thank you.
Okay.
Matt?
Yeah. So, and Joan, prepare to correct me as I am not, I just play the rules lawyer. I think the goal here is to ensure that there's two things. First is that there's robust participation. That's what I'm hearing. And second, that it is meaningfully acted upon for future proceedings. So the issue I think I've heard articulated from siting board staff and from members of the siting board is that doing it here in this proceeding may not have that associated discussion tied to it. And therefore, instead of tweaking the language, right, I think Ms. Evans had indicated that she had felt some of the language wasn't in line with the decision. Instead of tweaking the language, incorporating the ideas to enhance our engagement with environmental justice, would be preferable through that notice of inquiry, provided there was proper notice. And if we did it here in this proceeding, I think the concern was this is the end of the proceeding that will have a Supreme Court appeal pending. And while this doesn't have a bearing on the Supreme Court decision, I think that certainly isn't a robust process. And I think you were getting at it. Why couldn't it be both? And I think the reason why I'd go back to why I heard it couldn't be both, and I'm not sure, I'm hypothetically answering my own hypothetical at this point, is that if it was going into this proceeding, we would have to look at the language and ensure that that language was appropriately tuned to the decision. Am I right with that concern, Ms. Evans? I mean, you had other concerns too. I think that was one.
So one quick, and I appreciate that. And then one other question for clarity. So when you guys have commented that you're concerned about, oh, should there be a larger stakeholder discussion? Are you saying that you don't think the amendment as proposed by CLF represents, or CLF does not represent accurately the environmental justice community? That's your concern of that the voices, there are other voices out there, just want to get clarity on what the concern is.
Yeah, and I would certainly say that I don't think there's many fiercer advocates for environmental justice than Consumer Law Foundation. So let's be clear that that is not my characterization there. But what I would say is that the process in this specific case is over, right? It's the only last step is a appeal at the Supreme Court. So there's not a hearing or anything going along with that.
Can I just perhaps, is this correct then, just building on that statement, Chair Nelson, then that to amend this certificate does not effectuate the change that it sounds like folks are seeking, right? To give some other kind of directive to the citing board staff about how to conduct proceedings or how to enhance proceedings to provide better access and communication going forward is a way to get at what CLF and Green Roots have raised in a forum that would really impact the proceedings, I would imagine, for the better, right, going forward on a big picture, as opposed to amending a certificate that, as the chair notes, is at the end of a process.
Yeah, and I would say implementation of new standards and processes, it just generally from my time at the department, is always best done when it impacts a wide range of stakeholders. And this would absolutely impact a wide range of stakeholders. So I would be reticent to make a decision based on a single view in a single case, rather than having it be done in a more general proceeding.
Do other board members have views? Commissioner Woodcock, I see your hand. Go ahead.
So I think there's an urgency that we're all hearing to move forward with implementation of the comments we've received that is reflected in the amendment from CLF, but also through comments received in the NOI, but how to move that with the urgency that I think we all are hearing. And this is further complicated, but the sentiment from the amendment as proposed is that is a signal to the next citing board. So I wonder if and I look to the staff on this, if there could be some effort to codify that the effort that has occurred through the NOI isn't lost with the transition, and that I'm thinking out loud, but whether there could be at the discretion of the chair, a scheduled meeting where there's presented the feedback received from the NOI to the new board. And with that there be options provided of next procedural steps to implement environmental justice policy change at the Energy Facility Siting Board. I'm trying to think through how to procedurally move this in a constructive way.
I think we would have to make a motion for an amendment with a specific direction to siting board staff. That would be probably the appropriate next step, which I can attempt to do if we think this is the appropriate time to do so. But I don't want to step on deliberations. We would further get to deliberate, but I'm just saying it would be an amendment. Am I correct there, Ms. Evans?
That's correct. If you wish to give specific direction to siting board staff to perform certain actions or to require the staff to provide information to the next board, which the staff would do anyways, but if the board wants to ensure that the information is provided on to the next board, you can direct staff to do so. And it would be an action of the board, this board, recognizing that the board is about to change.
General Counsel Evans, does that preclude us from, does that close out EFSB docket 21-01?
So if it depends on what the board wants to do, the board would need to decide that the board could decide, let's say it this way, that addressing these matters is not appropriate in this particular docket, and therefore shifting the matters over to the NOI, which is where we've been discussing it might be the best place to go. And that would be the vote of the board. The board would need to say, we're not going to do it in this docket, we're going to do it in this docket over here. And that would be an amendment. We have a main motion on right now. The main motion would need to be amended. That's procedurally how it happens.
So procedurally, there'd be two, we would have to vote up or down on the proposed amendment, and then whether it's, Commissioner Nelson or whoever could say like, okay, we're also going to make a motion to incorporate these proposed amendments into the NOI. Is that accurate?
Well, it would be, what it would be, I believe the way that it would normally go is that someone would motion to amend the main motion that we have in front of us right now, that the board has in front of it right now, and then vote up or down on the amendment, and you can have discussion on the amendment, and then a vote on the main motion as amended. And that would be the action of the board.
But I thought the proposed amendment was germane to the certificate.
The proposed amendment is germane, so you have to decide what you're going to do with the certificate, but you can also provide direction to staff to address the ideas from the motion to amend in another proceeding. And then we would have to take it up in the next proceeding and decide what type of process would be necessary.
I feel I just trespassed me on a little bit further. I feel like we're just kind of going around in a vicious circle here. It's like, how can we amend something on their certificate, but at the same point, we want it to be a separate issue?
We're amending the motion that's in front of us, not the motion to amend, but the motion to act on the motion amendment. It's confusing. They're both called amendments, right? Yeah. So we have a motion to act on the motion to amend that's before the board right now. You would amend that motion.
Understood.
Sorry if I'm not clear.
No, it might help if we actually try to do it, and that might inform how we get there. I think I don't want to circumvent the deliberations either, but I think Chair, earlier you were saying that you're willing to give a stab at it. So
I'll take a stab at it. Let me think for 1 second, Joan. Right. So we need to, the first thing let me stop talking about it and just do it. I move to amend the main motion by striking the word grant and insert the word deny. Furthermore, I would move to add the following into the end of the main motion. The siting board recognizes the importance of environmental justice policy considerations contained in the CLF and Green Roots motion to amend, and thinks that they would enhance, they have the potential to enhance environmental justice in the Commonwealth in order to develop the concepts and changes to the board's practices, and to allow a more diverse group of stakeholders to provide input into these practices. The board concludes the most effective way to address those issues is contained in the motion to amend the siting board's notice of inquiry, docket EFSB 2101. Therefore, the siting board directs staff to accept the motion to amend as a proposal in the NOI, and considers to address the provisions regarding environmental justice contained in the motion to amend the notice for EFSB 2101. I'm going to pause there.
Let's get a,
yeah.
So I think we need a second, and then we can deliberate on that motion. Is that right, Joan?
That's correct. You do need a second. If Matt's making a motion, you do need a second to that motion. And it's a motion to amend the main motion.
Mr. Casey?
Yeah, I would just say kudos to Chair Nelson for thinking on the fly. And I know that poor staff is going to get stuck with, scribing it all. But I would say, from what I understood what he said, I would second his motion, which is to deny the initial motion amendment, to incorporate those amendments into the NOI, aka EFSB 21-01.
Okay, so we have a motion and a second. So now we can deliberate on this motion. And so I think, in terms of what we're trying to do, I think we're getting there, but I'm wondering if, and perhaps I could look to Joan for a little bit of help. I'm wondering if we can sort of streamline the motion a bit, but I think all the concepts are there. Is that something that we can do as a group?
I think the goal, White, is to make sure that and Joan, this will correct me, I think I got it right. The motion is to incorporate what CLF and Green Roots are putting forward, to ensure that that is incorporated re-noticed into the siting board docket. And I think that's what it did. I'm looking back at the
and for staff to consider it in that docket and make it part of that process. Is that what you're saying?
Yep. And let me read it back one more time for people in a little more, less of a stream of consciousness now that I got it here. Okay. So, the siting board recognizes the importance of environmental justice policy consideration contained in the CLF and Green Roots motion to amend, and it has the potential to enhance environmental justice in the Commonwealth in order to develop the concepts and changes to the board's practices and to allow a more diverse group of stakeholders to provide input to these practices. The board concludes the most effective way to address these issues is contained in the motion to amend and the citing board's notice of inquiry in docket 21-01. Therefore, the citing board directs staff to accept the motion to amend as proposed and considers to address the provisions regarding environmental justice contained in the motion to amend the notice. That's right. So, Joan, now I'm going to leave it to you to see how much I hacked that up.
I think that it provides a statement of intent. I think that's what the purpose was, the intent of what the board's trying to do, which I think is good. That's also the message to the next board that Commissioner Woodcock was asking for, that the intent of what this board wants to do. And then it directs staff to accept the motion as part of the NOI and to consider and address it there with the broad group of stakeholders that are in that process. There will need to be, as I said before, and Ms. Sharkey can maybe elaborate as she's the presiding officer on the NOI, but it would need to provide more process and notice over on the NOI side, but this board doesn't. I don't think this board needs to address that. Staff will address that once this information travels over there, if that's what this board wants to do.
Could I just confirm my understanding too, and then I want to hear from others as well, so that the motion, as we're sort of working through it, denies the CLF Green Routes motion to amend the certificate, but directs the staff, consistent with as we've just been talking about, to enhance its proceedings for environmental justice purposes.
That's how I read what Chair Nelson stated. And I think the two ideas were connected. Not do it in the certificate, but not lose it completely, move it over to a different proceeding. I think that is how I read the motion to amend that Chair Nelson just stated.
Right. Makes sense.
My understanding as well.
Ms. Evans, would you say that when it's renoticed would allow substantive comment and substantive action on what CLF and Green Routes has put forward in docket 2101, based on what ironically I said?
I do think so. I think that the docket 2101, while it was opened on a more procedural basis, as indicated by Ms. Rubin, I think the board has inherent authority to broaden that proceeding to accept more substantive considerations.
And is it pretty clear or self-evident, General Counsel, that that'll survive changeover on this body? Because it'll be incorporated into an open and active docket.
The open and active docket will continue past the current administration, yes. And where the new administration wants to take the docket, we do not know. But it would be their prerogative to take the docket as they forward as they wish. It would be my view.
I have a quick question. I'm not too keen on continuing to pass that responsibility onward, not that because it hasn't been held as far as environmental justice, I feel, here in this case. As such, if I value the initial amendment, which please let me know if it's a moot point now, because there's been a motion and such. Can you just give me clarity regarding where we are in that process, as far as we're voting now on that amendment to push environmental justice to the next board and responsibility. And that if I vote no, it's regarding that versus the initial amendment, correct?
So the board has not yet voted on Chair Nelson's amendment to the main motion. You'll need to vote on that first, and that's where it is right now, procedurally.
Okay.
And then if that passes, then the main motion would then be a motion to deny, but you'll direct staff to move the information from the motion to amend into the NOI. That's procedurally where we are.
I have one quick question, because again, I really value my peers. And it seemed that through the process, when you heard from community and other organizations, ample ones who were talking about environmental justice and expressing a concern that now you're focused and concerned about making sure that right conversation is being had and versus taking or holding in responsibility now in voting for the amendment. Curious about that duality that I'm seeing here. I don't know if anyone wants to comment on that. It may be just my perspective, but there now seems a big focus on stakeholders, environmental justice, giving people a voice, and people spoken. Yet we're here. And now you're pushing it on. And if I'm misunderstanding anything, please do let me know. I appreciate that.
Yeah, I'll answer that one quickly. I think that whenever we're doing a general inquiry for a future implementation of a standard, it's generally done through an open investigation that's broad, so that the standard moving forward has notice and everyone has ample time to comment and say, I like this, I don't like this. Here's an additional idea. In the current case, I think to draw a parallel, it's been a long case, and certainly it has been a heavily opposed case. And we've made a number of different decisions, and some of those decisions have gone to the Supreme Court. There's a lot of context there that's relevant to this case that I think certainly, I mean, I don't think it would be, like I said earlier, we would not have the ability to do additional process in this case, from my understanding, because this would be the last step to a certificate to amend the decision. So there isn't any input ability at this point. And that is a case that's under appeal at the SJC. So that's the distinction that at least I'm drawing procedurally, where substantively, I think what Green Roots and CLF put forward, and I mean, even in the last conversation, Ms. Johnson, I think we were having, I think we were talking a little bit about this case or something going forward. I think, at least for me, in my opinion, the board can enhance its ability to engage with the community and enhance its environmental justice capabilities, and has done so throughout the course of this proceeding as well. I think that we want to make sure that we're doing that across the board.
I hear you. But again, as I mentioned, Conservation Law Foundation is the voice that's valued for energy equity, environmental justice, energy justice. And so to push it along to say, let's hear from everybody and other stakeholders, and to have an appropriate forum for people to share a voice, they're representative and have held that space. I'm not sure why it's not valued now versus how you think it would change.
So I think, at least in my view, the goal of what I was trying to motion is to take the actual words and phrases that are articulated in the motion, take that entire motion and its substance and move it. So we are taking the actual work product of CLF and putting it as the center of what has to be considered in common.
I guess I would just, I would say too, I don't necessarily agree with the characterization that we are kicking this forward for more process only. I think what we're saying is we want to go on record giving a directive to the staff that this is important and that we want to use this other proceeding in order to finalize a pathway for enhancing their efforts and the board's efforts in terms of access and communication. And so I think this is a way to memorialize that interest as raised by CLF and Green Roots for proceedings going forward, meaning the next actions that come before this board, we will have gone on record saying, we think this is important. We want to figure out how best to enhance the proceedings.
I hear you.
I think that amending the certificate for the East Eagle project does not accomplish that for other projects going forward. I think we are going on record saying we think there's opportunities to make enhancements here, and here's the better place to memorialize that, is my view.
I hear you. I appreciate that. I appreciate all of it. I still think the best way to support environmental justice and such would be on the initial amendment. I'm very confident that the next board will have a great understanding maybe of EJ or such. It's very different versus needing to be set up with such versus this board supporting it now. And that's my opinion, I thought.
Thank you. Do other board members have thoughts, questions about Chair Nelson's motion?
I believe, as point of order, Chair, I believe I seconded his motion.
Yes, you did. Thank you for that, Mr. Casey. And so we have a motion and a second, and we're having deliberation on that seconded motion now. I want to not rush any further discussion on it. And then the next step would be a vote on this motion and then back to the main motion. I've got that right, Joan? Okay. Is there further discussion on the seconded motion that we've just been discussing? I am not seeing or hearing any. And therefore, I think we can take a roll call vote.
Chair Card, I don't have additional questions or discussion items, but if General Counsel Foster Evans could just clarify what we're voting on and the two votes, I'd appreciate that. I'm sorry to belabor the issue, but I just want to be clear on the two voting items. Thank you.
I think, yes, thank you, Commissioner. I think that would be helpful. So I will look to General Counsel Evans to help us with that.
Thank you. So I believe procedurally where we are, as was just stated, is that there was a motion by Chair Nelson to amend the main motion, which included making the main motion a deny instead of an approve or grant, and adding directive to staff, an intention for attention of the board to have staff look at the issues in the motion will amend, and a directive to staff to look at those issues over in the NOI proceeding. That and where we are is a vote on that amendment. And then if that amendment were to pass, then there would be a vote on the main motion, which would then become a motion to deny and a directive to staff to address the issues that we've been discussing over in the NOI proceeding. I believe that's where we are.
Okay.
One point of order, I think it also is a requirement to renotice, Joan, that case. Am I wrong there?
We would need to provide some additional level of notice. Do you want to instruct staff to do so?
I am not. I just want to make sure we're doing it correctly, because I don't want to just say move it over there. I do want to make sure that it is renoticed.
Can we just say something like in accordance with rules and procedures instead of directing the renotice per se?
Yeah, that's fine.
We could do that, yes. Or staff, or you could direct us to renotice the NOI inclusive of the issues raised in the motion to amend the certificate. And what could be, and the way that could be done is at the end of the motion presented by Mr. Nelson, which actually would be an amendment to the amendment. And I believe that you would, now that the amendment's already made and seconded, I think to amend the amendment, you actually have to have another motion and second to amend the amendment, which is getting very confusing.
Mm-hmm.
So perhaps Chair Nelson wants to either state his original amendment and add a sentence to the end of it, but we'll need a second on it, or you can just state that you want staff to go renotice this and not put it in the amendment, and staff will do so. And it could go, we suggest that we reduce this ruling to a writing at the end, and we can put that sentence in the ruling telling staff to renotice the NOI.
I am fine ensuring that the intention is to renotice, and that I know that citing staff would have to do that as a course of proceeding anyways. I don't think we need to go to the third dream level and motion an amendment to amend an amendment. So let's not do that, because I think that's just going to overcomplicate what we're voting.
It is complicated, I agree. The intention of staff would be to renotice the NOI inclusive of what the board asks us to look at in the NOI.
Okay. So with that, unless there is any further discussion on the seconded motion for the amendment.
I have one quick question.
Of course. Yep, go ahead.
And it has to do with, and correct me if I'm getting it confused with which amendment. The portion, while I value it, as you can imagine, supporting the board's understanding of EJ, the part of the current amendment that I'm concerned with is actually denying the initial. Is there any way where you're not denying it, but you're then allowing the, like you said, the spirit where the next board would be looking at all those elements of EJ? Is there any way where it can capture both?
Can I ask a question?
Please.
You want both to occur, and so your intention would be, what would you want the board to do with the certificate?
That's a great question. And I would like it amended as initially requested by CLF. But if there's a concern from this board about the but I don't know if it matters, if there's a concern about the environmental justice process procedure, can it just be some text added to clarify that will then be looked at by the new board rather than how it's being structured now to deny and then having the board look at it, if I'm understanding that was the process.
Well, I think if we amend and vote on the certificate today, Ms. Evans, is that a final matter?
But could we modify it so we're supporting what CLF is proposing, but then add it there that it will be looked at the next board, or it can't be that bridge?
Well, I think that's what we've been discussing this whole meeting, is that the proposed amendment by CLF this is not the right form. It's not, we can't amend the certificate to address that all-encompassing issue.
I know.
Because it would undermine all the deliberations we've already had.
I didn't think it did that per se. We can just go ahead with the vote and I can vote how I feel, but just wanted to at least throw that out there, because for the two-part now vote, I value one part of it. I don't value the other. And I can vote as I need to that way, or abstain or such. But so I just wanted to see if there was a sustainable solution regarding that issue I had. If not, we're still back there. I'll vote accordingly. But just wanted to bring that up if possible.
Do you want staff to jump in? I'm sorry, Chair Card?
Oh,
Or
no, I was thinking it through, right? I was really trying to think about if there's a way to remedy what Ms. Johnson is raising, and I'm not getting there in my mind. But we can come back to staff as well, but I do see Commissioner Woodcock's hand. So Commissioner.
Yeah, it goes, I think, Ms. John, how I was trying to isolate the difference between amending a final decision, which I am not comfortable with, versus what the staff believed, which was within the right of the section of the regulations that do allow you know, a amendment to it. And I don't, just my own sense, I would not be comfortable amending altering a final decision at this time.
So you don't want the original language? Okay.
Correct.
Thank you.
Okay. We have a motion and a second. And I appreciate the conversation and deliberations that we've had on that motion and second. I want to be sure that I don't cut off any further discussion before we have a vote. And this is the motion on the amendment to the main motion, and then we will come back to the original main motion that was before us. So at this point, I think we are ready for a roll call vote, please.
Would you like me to call the vote?
Yes, please, Mr. Green.
Thank you. Chair Nelson.
Aye.
Commissioner Fraser.
Aye.
Commissioner Woodcock.
Aye.
Mr. Bonfilio.
Aye.
Ms. Johnson.
The two-part vote, correct? I prefer to abstain.
Okay. And Mr. Casey?
Aye.
And Chair Card.
Aye.
So the motion to amend the main motion carries by a vote of 6 in favor, 1 abstention.
Okay, thank you. And so now we have a motion and a second on the main motion, which has been amended. Am I saying that right, Joan? Yes.
Yes.
So we will go back unless there is any further discussion and take a roll call on the main motion as amended.
Yes.
I think we are ready for the roll.
Chair Nelson,
Aye.
Commissioner Frazier,
Aye.
Commissioner Woodcock,
Aye.
Mr. Bonfiglio,
Aye.
Ms. Johnson,
I will abstain.
Mr. Casey,
Aye.
and Chair Card.
Aye.
So the
Okay,
vote on the main motion as amended passes 6 in favor, 1 abstention.
thank you. Okay, so at this point, thank you for that. And recognizing that I don't believe we have any additional matters before us today, I would direct the staff to please draft a written ruling that memorializes the votes that have been taken here today for my signature. And I want to take the moment while we're still in open session to thank the board very much for your thoughtful conversation and the spirit in which we worked through the conversation and the amendments today, the motions today. Thanks to the parties for your presentations today as well. And of course, to the staff for your work and guiding us through here yet another session. It's greatly appreciated. So thanks everyone for your time and service today. So with that, and understanding that we don't have any further matters, I think we need one last motion today, which is a motion to adjourn the meeting.
So moved.
Do we have a second?
Second.
I think we can
Chair
have a roll
Nelson.
call. Yep, thank you.
Chair Nelson,
Yes.
Commissioner Frazier,
Aye.
Commissioner Woodcock,
Aye.
Mr. Bonfiglio,
Aye.
Ms. Johnson,
Aye.
Mr. Casey,
Aye.
and Chair Card.
Aye,
The motion carries unanimously.
thank you. All right, we are now off the record. Thank you very much, everybody. Best wishes to you and enjoy the rest of the afternoon. Thanks everyone for your time.
Thank you.
Steph.
Bye-bye.
Thank
Happy
you.
New Year, everyone.
Bye-bye.